Hello and welcome to the topic on registration of a company. This is also a topic under the company law module. In this topic, you're going to understand the process of registering a company. We are also going to understand the company constitution. What does the company constitution entail? We're also going to explore the memorandum of association, be able to understand the articles of association, and also be able to understand the formal steps that are used in incorporation of a company. So I invite you to take keen note of the discussion so that by the end of the lesson, you can be able to understand different concepts in the registration of companies. We begin by an introductory review, and we are saying we will focus on formation of companies and the procedures that are involved, and also the formalities. We will also look at various formalities for registration. Now, we have very, very important documents that form the company constitution, and they form also the basis of the process of registration. So there are documents that we cannot be able to do without as we undertake the process of registration. So the major documents are what we call the Memorandum of Association and also the Articles of Association. Now, we are saying that the Memorandum of Association, it's a document that simply is going to define the relationship with the outside world. And this relationship is between the company and the outside world. And this particular document is very, very important for registration purposes of the company. We have various contents, main contents that are found in the Memorandum of Association. Number one is the name clause. This is a very, very important clause because it will be able to tell us the name of your company, and if it's a private limited company, then it will have the word limited at the end. If it is a public limited company, they will have the letters PLC at the end. So the name clause is a very, very important clause within the Memorandum of Association. Then we have the registered office clause. So this particular clause will tell us on the location which state is the company that is being proposed to be formed, the registered office. So we need to have a physical location of a particular office or the office of the company. Then another item in the Memorandum of Association is the object clause. The object clause is very, very important because it states the purpose in which the company exists. And once you state the purpose of the existence of the company, then you are expected by the law or the company law to stick to those particular objectives. And that is key for you to be able to note. And then we have limitations of liability clause. So it will either state whether it is limited or unlimited. That's very important also to be able to clarify there. And the capital clause. The main purpose of the capital clause, of course, is to detail the maximum capital a company can raise. And of course, it goes ahead to explain divisions of such capital. It explains how divisions is going to be done in terms of how many number of shares a shareholder will be able to get. And finally is the association clause. And it indicates that any person who has signed the Memorandum of Association, because it should be signed at the end, has agreed to be associated with that particular company. And for public limited companies, the requirement in terms of those that sign, they should be at least 7 people. So that's very, very important to know those parts of the memorandum of association, so that as you do any registration, you can be able to find out whether all these details that you have mentioned as the contents have been adhered to, and what are they saying. It is very, very important also to read the contents of those clauses. Now, there are situations where we can be able to alter the name of the company, and those situations are very, very specific. We do not just wake up and decide to alter the name. And we are saying the first situation that we may be able to do alteration of the name is through a special resolution. And through the special resolution, then we can be able to get approval of the registrar of companies. And that approval, of course, is done in writing. And the other one is no approval will be required if the company is proposing the addition or deletion of the word private. We have companies that are already in existence. Maybe they want to clarify or add the word private. There may be no approvals for such kind of alteration. But if the alteration is a major alteration, that's why we are saying in our point number 1, then a special resolution has to be arrived at. Now, alteration of the registration, and in this particular discussion, we are saying it may involve the changing of the office location from one place to another within the same town. Yeah, so it is very important to note that when we want to alter the registration clause or the location clause, it's very important to know it is also possible to be able to do it under the Companies Act, or we can also be able maybe to be moving from one location to another in the same particular country. So remember, we have just talked about the registered office clause. So alteration of the registration or the registered office is what we are discussing. When can it be able to happen? Now, I have just talked about the object clause, and I said that it states the purpose as to why the company exists. There are also situations that would lead us to alter the object clause. And number 1 is to enable a company to carry on business more effectively. Maybe we have realized that the way we have stated our object clause, it is hindering us from being effective or being able to carry out more business. So those particular scenarios would allow us to alter the object clause. And also number 2, another reason why we alter the object clause is enable a company achieve its purpose more effectively and efficiently. The third one is to amalgamate with any other company. When we talk about amalgamation, is the process of two companies coming together, either through what we call mergers. So two companies will come together to become one, or what we call takeovers. So in that kind of a scenario, remember, we cannot now use the two names, or we cannot now adopt all the object clause of each company. So that is a situation that may necessitate the alteration of the object clause. When two companies are coming together to become one, we need to review because now we are coming together. Maybe we want to improve our efficiency. We need to review. So what was the objectives, or what were the objectives of each of these companies, and what is it that we can be able to do? And lastly is to enlarge a company's operational area. Now, the other document, like we have said in the company constitution, very, very important is the Articles of Association. And we are saying It is a document that is going to elaborate the basis in which internal affairs of the company will be managed. And some of the contents of the articles of association include the share capital and rights variation. That is very, very important to be able to note. And also, the other one is the transfer and surrender of shares. So in case shareholders needs to transfer shares or surrender shares, the articles of association is going to dictate how the process is going to be carried out, and any limitations that we need to observe as transfer is being done. Another content of the articles of association is the alteration and reduction of capital. Sometimes we need to alter our share capital. So what is going to happen? What are those situations that we can be able to alter? The other one is the voting powers of each members. There are situations that will require us to take a vote. So the articles of association dictates how that is supposed to be done. Another content or another part of that particular document is the appointment and directors' powers. So we have directors of companies. To what extent are they supposed to exercise their powers? And finally, the articles of association will also mention issues to do with winding up, bringing to an end a company. We have different situations. We are going to look at that when we discuss our topic on winding up. Now, what are some of the legal effects of the articles of association? Number one, it binds the company to each member. So each member is bound to the company. And the second one is that it binds each member inter se. That is to mean that it binds each member to other members. So number one, members are bound to the company, and then members are also bound to other members. That is very, very important to understand the legal effects. There are situations that we may need to also do the amendments of the articles of association. We are saying a company can alter the contents of the articles of association by adhering to the following conditions. So these are simply situations that are going to lead us to alter the articles of association. Number one, alteration should not introduce new terms contrary to the company objectives. Remember, we already have stated our object clause in the memorandum of association. So in case we want to do any alterations, because that means now as companies we may be deviating from our purpose, we are saying when we want to alter the articles of association, then we should not introduce anything new that we intend to do. The other one is alteration of the article should not remove any person from the company membership. So we should not participate in alteration of companies' articles of association with the sole purpose of removing somebody from the company membership. And the other one is alteration should not introduce persons who are members. So we cannot just pick people from outside who are not members of a company, and we use that as a basis of amending our articles of association. Now, once you present these particular documents, the registrar of companies is supposed to, once they are satisfied that the documents are satisfactory, they are supposed to give you a certificate of incorporation. And so now we are looking at the formal steps. Once you have been able to put your document in place, your registration documents, we begin by number one, name preservation. We begin by preserving the name. So based on the name that you are thinking of, you can approach government offices to be able now to reserve the name. And of course, it comes with cost. In some East African countries, probably for name reservation, they can be able to charge maybe $10. The other one is a preparation of a constitutive and other document, or preparation of a constitution. So you prepare your constitution. Within this particular documents now is where we find the memorandum of association. We have discussed it in details. We also find the articles of association. We also find the statement of nominal capital. And when you talk about the statement of nominal capital, this kind of a statement is also called the statement of authorized capital. And this particular statement, it refers to the designated or assigned share capital of a company. And finally, as we seek incorporation, we can also present a list of persons who have agreed to be directors in the company. And then after that, the documents are stamped. And then, so stamping is also very important as you present these documents to the registrar of persons. Then after the documents are stamped, you do the presentation to the registrar of companies. And then finally is the registration of the company and issue of the certificate of incorporation. But of course, the office of the registrar has to confirm that the documents that you have presented are meeting the criteria, that the checklist that has been provided, and that you have been able to submit all the documents. So it is very important to understand these particular steps, because anything contrary to these, then you may not get to the place where you receive your certificate of incorporation. So we have talked about memorandum of association, articles of association. I have clarified on what is the statement of nominal capital, and then all the people that have agreed to be directors. Now, we have what we call the certificate of incorporation, and we are saying it is a certificate issued by the registrar on the registration of a company. And then, of course, this certificate is going to signify the birth of the company. Now, part of the things that you are going to find inscribed in this certificate will be able to show the name of the company, and then it will also be able to show the serial number of your company. It will also now have the signature of the registrar of the companies. That shows that they have approved the registration process, and also it will also have the seal of the registrar. All these are signs to show that the document that you are having is a valid document, a valid certificate of incorporation. Most institutions will of course be required to display this in their offices as evidence that you have been incorporated and you have been given the license to be able to operate. So that will bring us to the end of that particular discussion. I invite you to do more research on these particular areas so that you can be able to understand and improve your knowledge around the registration of company.